Okay, welcome back to yet another episode of Intellectual Property. In today's class, we're going to be talking about copyright duration, or how long the copyright term in a work of authorship lasts. So, under Section 302 of the Copyright Act, for works created, as it says, on or after January 1, 1978, copyright protection begins when a work is created and typically lasts for the duration of the author's life plus an additional 70 years. Now, this was a big change from the way copyright duration had previously worked under United States law. So under the initial Copyright Act of 1790, the copyright term was 14 years, renewable for another 14 years, so a maximum term of 28 years. And subsequent copyright acts extended that term, both extending the original term and extending the renewal term. But it wasn't until the Copyright Act of 1976 that the United States shifted from a fixed copyright term of a duration of years, in other words, 14 plus 14 or 28 plus 14 or whatever, right, to a copyright term typically based on the life of the author, right? And that was essentially a function of the United States copying the copyright term from the Berne Convention, which is the convention on literary works that has been adopted by the overwhelming majority of countries and kind of has come to become the standard in international copyright protection, for better or for worse. So initially, the Copyright Act adopted a term of the life of the author plus 50 years, and then subsequently the Copyright Term Extension Act, or better known as the Sonny Bono Act or the Mickey Mouse Protection Act, extended the term for an additional 20 years, from the life of the author plus 50 years to the life of the author plus 70 years. Now, we just talked about joint works. In the case of a joint work, the copyright term is tied to the life of the longest lived joint author plus an additional 70 years. So in other words, whoever dies last, that's when the life of the author term ends, and then an additional 70 years are tacked on after that, with copyright ownership nonetheless passing to the estate like any other kind of property. In addition, for anonymous, pseudonymous, and works made for hire, there is still a fixed term, and the fixed term depends on whether or not the work is, or rather whether or when the work is actually published, in other words, made available to the public for consumption. Okay. Here, a more concise explanation of the copyright term. And if you're interested in computing the copyright term of particular works, especially older works, and determining whether and when some of those works may have fallen into the public domain, right? Because until the Copyright Act of 1976, there were what's known as copyright formalities, which had to be observed in order for a work to be protected. Among other things, a big problem or an issue that many authors faced was that if a work was published without copyright notice, it went into the public domain automatically, right? And in addition, if a copyright owner failed to renew the copyright term, or the author failed to renew the copyright term, then the work could also pass into the public domain. So some older works, the copyright term ends earlier than it could in the event that somebody made an error in satisfying the formalities. Under the Copyright Act of 1976, there really are no formalities anymore, and so the Copyright Act term is going to last for the full duration, regardless. But in any case, if you want to compute in a more kind of granular way the copyright term of particular works, Cornell University has produced a chart detailing how copyright applies to different categories of works of authorship created at different points in time, depending on whether or not they've been published and so on and so forth. So if you Google Cornell copyright chart, it'll come right up. Super useful tool, and I highly recommend it. Okay, so what happens when the copyright term ends? Well, that means that the work goes into, as I described, the public domain, right? So in other words, when the copyright term ends, then the work is no longer protected by copyright. And at that point, anybody can use the work in any way they want to without the permission of anyone else, right? In other words, you can't stop people from using a public domain work in any way that they want to use that work, right? Okay, and as you can see, the history of the copyright term has been to get consistently longer, right? And there's a big debate over how this gradual extension of the copyright term plays into our different justifications, theoretical justifications for copyright protection in the first place. In other words, is this continual extension consistent with a consequentialist or economic theory of copyright, or does it reflect the kind of more Lockean or Hegelian way, Kantian way of thinking about the justification for copyright protection tied to natural rights or moral rights of the authors? And this chart here just shows you the consistent extension of the Copyright Act. Some people were anticipating another extension once the 20 years granted by the additional 20 years granted by the Copyright Term Extension Act ended. At least at this point, it doesn't look like it's going to happen. So copyright protection is going to stick at life plus 70, but you never know. It could come up in the future. So part of the theory behind granting copyright protection is that copyright ownership encourages publishers, copyright owners, to make works available to the public. Unfortunately, it doesn't seem like that prediction about the incentives associated with copyright ownership has really played out in practice. So you'll note this interesting chart showing the availability of various books from originally published in different time periods on Amazon. You'll see this peaking in 1910, which then gradually dramatically falls off in 1920, and then continues at a low rate until it reaches a high again for more recently produced books. Well, the problem wasn't that people stopped writing books in the 1920s and 1930s. It's that books published before 1923, 1924 are now in the public domain, and therefore anyone can make them available, and they don't have to license the work from a copyright owner, whereas works produced later are typically protected by copyright, and therefore there's this transaction cost. There's this cost associated with making them available that doesn't exist for public domain works. So as a practical matter, this is a pretty nice illustration of the fact that contrary to the theoretical incentive provided by copyright ownership to make works available, in reality, public domain works tend to be much more widely available to the public because anyone can host and distribute them, whereas works that are protected by copyright are often much harder to get a hold of. And so the out-of-print problem, as it were, is much more looming when it comes to works that still fall within the scope of copyright protection. And this was posed at least on one level in Eldred v. Ashcroft, a interesting and important Supreme Court case about the copyright term, but also argue about the kind of the fundamental values and justifications associated with copyright protection. So what happened in Eldred v. Ashcroft? Well, a group of plaintiffs who engage in business practices that involve distributing public domain works objected to the Copyright Term Extension Act's increase of the copyright term by 20 years, arguing that Congress was taking works out of the public domain when it shouldn't be doing so, and that was improper. And they had a number of different arguments available, right, that they made, none of which were ultimately successful before the Supreme Court, but for different reasons, right? So one core argument was, or kind of one of their arguments was that, look, Congress can't just keep making the copyright term longer and retroactively extending the copyright term because the intellectual property clause explicitly says that copyright can only last for limited times, right? And if Congress can keep extending the term, then ultimately the term is not, practically speaking, limited at all, right? Congress could make it effectively unlimited by just continually increasing it over time. Therefore, it's not consistent with the constitutional authority granted by Congress to create copyright protection in the first place. Well, the Supreme Court, an opinion written by the late Justice Ginsburg, rejected that argument, saying, in effect, limited times just means not forever. and it's not forever. Life plus 70 is not forever. And in fact, life plus 90 or life plus 200 presumably wouldn't be forever either. This is within the discretion of Congress to determine what the appropriate term is going to be. And Supreme Court is not going to second guess the Congress's policy decisions about what the duration of the copyright term should be. So long as it's not forever, it's for a limited time, no constitutional problem. Okay, one of the other arguments advanced by the plaintiffs in Eldred v. Ashcroft was that this is a First Amendment violation, right? Extending the scope of copyright protection in this way limits their ability to use works that would otherwise be in the public domain. And there are First Amendment free speech related problems with Congress's keeping works out of the public domain. And this kind of gets to this inherent tension in copyright protection. I mean, after all, the kind of prevailing view of copyright is that the justification of copyright is to encourage people to speak, to encourage people to produce works of authorship by enabling them to stop other people from using those works to speak in different ways. In other words, copyright owners are encouraged to engage in protected speech by giving them property rights that enable them to limit the speech of others. Sort of implicit in this First Amendment argument advanced by Eldred, the Supreme Court also rejected this First Amendment argument, saying that, well, this is true in as far as it goes, that the extension of copyright protection to authors limits the speech of others who would like to use those copyrighted works in their own ways without getting the permission of the copyright owner of the work in question. But we have the fair use doctrine. And the fair use doctrine essentially provides that certain kinds of uses are non-infringing, or arguably provides an affirmative defense to a claim of copyright infringement. And essentially the Supreme Court said, look, the fair use doctrine does all the First Amendment work we need, right? Because there's a fair use doctrine, there's no constitutional First Amendment problem with copyright protection, because fair use encompasses all of the relevant First Amendment laden valued speech, and we don't need to have this additional analysis. All we have to do is analyze this in relation to free speech, in relation to fair use. Eldred, you're not actually making a fair use argument here. You're making a general argument about an entire body of work, arguing that it should be in the public domain rather than the ability to control speech involving the work in question should be limited by copyright. And if you want to make a First Amendment argument, make a first fair use argument, essentially, is what the court responded. That this is not the vehicle for a First Amendment claim, as it were. Okay, the third argument I think is the most, in many respects, the most interesting and most powerful, at least with respect to thinking about the nature of copyright protection and what we're trying to accomplish. Essentially what the plaintiffs said was, look, it's one thing to say that Congress is making policy choices about incentivizing the creation of works of authorship by increasing the duration of the copyright term. Okay, maybe in theory, some author might be encouraged to create an additional work of authorship if they thought they were going to get a couple extra years on the back end of copyright ownership, right? It's theoretically possible that that might provide an incentive. Now, does it really? Probably not, right? For one thing, it's going to be long after you're dead. For another, the overwhelming majority of works aren't valuable that long after they're created. In fact, the overwhelming majority of works aren't valuable at all ever, or certainly not for very long. So the marginal incentive provided to authors is, let's just say, limited at best, but at least it's theoretically possible that extending the copyright term could provide some kind of incentive to produce additional works on the margins. But the plaintiffs here said, look, Congress isn't just prospectively increasing the copyright term, it's doing it retroactively as well, right? Congress isn't just granting newly created works an additional 20 years of copyright protection. It's extending it to works that have already been created. And you, by definition, can't provide an incentive to create a work that's already been created, right? I mean, this additional 20 years of protection is going to protect, for an additional 20 years, works that have already been produced in the first place. You can't provide an incentive to create a work that the artist, that the author has already created. That has to be unconstitutional. That's violating the bargain between the public and the author. After all, remember the copyright quid pro quo, the IP quid pro quo says that the justification for intellectual property is that the public gives something in order to get something in return. In other words, the public gives authors copyright protection in exchange for getting works of authorship. Well, this is a terrible bargain for the public here, right? Because the public is giving additional protection in exchange for nothing, right? It's not getting any additional work. The work already exists. So why should there be this giveaway to authors? Why should the public give them additional copyright protection when they've already created the work in the first place? Presumably, the protection that was already granted was more than sufficient to incentivize the production of the work because the work was in fact produced. Now, the Supreme Court also rejected this argument, essentially applying the rational basis test and saying, well, Congress could rationally believe that there was some theoretical justification for this. And, maybe that justification is that extending retroactive copyright protection will encourage copyright owners to make works more available. Well, empirics say that doesn't actually work, right? That it doesn't seem that actually happens. And in fact, if anything, retroactively extending copyright protection makes works less available, as we've already seen, right? Works that are economically valuable, sure, the copyright owners are going to make them available, but the overwhelming majority of works are not economically valuable, and those works are the ones that are being essentially consigned to the dustbin of history. But as you know, rational basis test means that Congress can do whatever the fuck it wants. So at the end of the day, the Supreme Court basically just said, we're not going to evaluate whether or not this as a policy decision makes any kind of sense or not. We're just going to let Congress do it regardless. There are some really interesting dissents from Justice Stevens and Justice Breyer. I encourage you to check them out, especially the Breyer dissent. Breyer was a former copyright professor and wrote some really interesting stuff thinking about the duration of the copyright term, among other things. So definitely worth checking that out. And hopefully we'll have fun talking about these principles in class. I encourage you to reflect on sort of the theoretical justifications for the copyright term and the theoretical justifications for the extension of the copyright term. In other words, what, if anything, can a case like Eldred tell us about why we have copyright in the first place and how we actually think about the justifications for copyright protection?